Hi, I'm Michael Wax, and in this video we're going to talk about slip and fall accidents and trip and fall accidents. In the legal field, that's known as premises liability. My office handles a lot of premises liability cases. They can be very difficult, they can be very expensive to pursue, and they can be technical. So in this video I'm going to try to give you some information about what they're about and how they should be pursued. One of the biggest misconceptions that the general public has about premises liability cases, or slip and fall and trip and fall cases, is that if they slipped and fell on somebody's property or tripped and fell on somebody's property, that that person is automatically responsible for their injuries. That is the furthest thing from the truth. That is not the law. In California, you must prove multiple elements for you to eventually be entitled to compensation if you were injured on somebody else's property as a result of their negligence. I find the best way to explain the premises liability law is to analogize it to a baseball game. You have to get to first, second, and third before you ever get home. So let's talk about that. First off, you have to have an injury that is significant enough to make it worthwhile to pursue one of these cases. Just basic scrapes and scratches or minor bumps and bruises and soft tissue injuries usually is not sufficient to warrant pursuing one of these cases. So if you have an injury that is relatively significant, then it's something that you should speak to an attorney about and you should then pursue. In order to get to first base, you're going to need to prove that there was a dangerous condition. A dangerous condition can be multiple things. It could be an excessively slippery floor. It could be a broken tile on the floor. It could be a rip in a piece of carpet that you tripped over. It could be a broken handrail. It could be a multitude of things that were dangerous, that caused you to fall. You need to know what that is. You need to be able to find what that dangerous condition is. I oftentimes will get calls from prospective clients who are involved in a slip and fall or a trip and fall, and one of the first questions I ask them is, if not the first question I ask them after I get their name, is, what is it that you fell on? What caused you to fall? And sometimes they'll say, well, Mr. Wax, I don't know. If they don't know, chances are you're probably not going to be able to pursue that case. You're going to need to be able to establish the dangerous condition to get past first base. The second thing you're going to need to do to get to second base is notice. Notice is extremely important. You're going to need to be able to show that the defendant either knew or should have known about the dangerous condition. You're going to need to prove that they knew that it existed, or that they created it, or that because of their extreme negligence they should have known about it but didn't do anything to really learn about it and just kind of avoided it. You're going to need to prove notice in order for you to get to the next base. If you can prove that, then you got to get to third base, which is causation. You're going to need to prove that your injury was caused by the accident. That can be difficult, especially in situations where you may have a history of a problem with that same part of your body. So it's very important that you're going to be able to show that the injury either was caused by this accident or you had a pre-existing injury that exacerbated your problem. Causation is crucial. Once you get past causation, you're rounding third base and you get home, and that's when you can get your verdict or a settlement in the case. But you're going to need to prove those three things in order to get you home and to get your verdict. Thank you very much.